We want to welcome you again. We are really happy to see you. And my name is Robert Galliano. I am with Koppenbarger and Koppenbarger. I am not going to bore you with all of my background, but in essence, I've been doing it for over 35 years, and I have an advanced tax degree. And I also am a certified specialist by the State Bar of California. I'm a Veterans Administration certified attorney and a California real estate broker. So the background in education is really for being able to help all of you when you come in to see us. I am one of 10 lawyers, and our offices are throughout Southern California, San Diego, Temecula, Irvine, San Jose, Capitola, Sacramento, and actually we have one in Pasadena. The topics that I'm going to talk about today, I took a lot of material and tried to condense it into interesting subjects for you. I am not going to obviously do a dissertation on tax law with IRAs and retirement plans, but I do want to cover what I consider to be traps that you must avoid, only because we have seen these occur with some of our clients. And I will be talking about how retirement plans are transferred when you die. I'm going to be talking about distribution options for inherited IRAs and how distributions are controlled. I'm going to be talking a little bit about spousal IRAs and understanding IRA rollovers and conversions from regular IRAs to Roth IRAs. And then a topic that may not apply to all of you, and hopefully it does not, but that is IRAs in a divorce setting. So the topics are broad, but I'm going to be giving you kind of like the tip of the iceberg on some of this material. Now, retirement plans are transferred at death. And this is a very important point that I want to make. And I read into this actually yesterday with a person that came in to see me that did not quite understand that retirement accounts, pensions, IRAs, annuities, life insurance, these type of accounts are transferred by the beneficiary designations that you completed when you opened that particular account. And the problem that exists is that generally these distributions are what we call outright. In other words, your IRA may say that Johnny's going to get $200,000 upon your death. So Johnny will get the $200,000 without any protection or guidance, and obviously without any tax planning. So even though IRAs transfer specifically by designations in the beneficiary forms, the problem is that there's no protection or capability to provide guidance when the beneficiary gets the large sum of money. And that poses problems that we see all the time, which is basically, as you well know, you work hard for this money. You sacrifice, you spend a lot of time saving, you deny yourself from having maybe a triple McDonald's, and your IRA has a very large value. But when you die, if you leave it, for example, to somebody that has never worked for it, they're not going to have a problem cashing it out. They may not care that they have a big tax bill because they will have a lot of money left over. They didn't work for it. So they will, most of the time, cash out. And the term that I like to use is they will buy a Harley and not go to Harvard. Also, the beneficiaries are not aware of the rules and choices that a beneficiary or a spouse or somebody else may have. Sometimes a surviving spouse may just want to spend the money, just like maybe the adult child beneficiary. And again, these accounts are transferred with no protection. And if you have an elderly individual who's receiving the inheritance from an IRA, or they are disabled, they may not be able to manage the account. So generally what we want to do is to talk to you, discuss with you how the IRAs are going to be transferred, and discuss the options that you may have available to put in place some of these protections. We all know that the government is there to tax us at our death. They're not satisfied with taxing us while we're alive, but if we give money away, there's a gift tax. If we die at death, there's what we call an estate tax, a federal estate tax. And an IRA is not immune to being taxed, the regular IRA. And I took some numbers off of the 2023 tax rates. I just chose an income tax rate of 32%. Obviously, some of you may not be in that tax bracket. And I also chose a 40% federal estate tax bracket. Now, on the federal estate tax, currently, if you do not know, but all of you, including myself, have the ability to basically exempt from federal estate tax at 12.9 million each. So in today's environment, your IRA might not be subject to the 40% federal estate tax, but for individuals who have a larger estate, the federal estate tax may come into play. So the point of this particular slide is to make you aware that IRAs are subject to tax at death. That's the point here. The other important, this is a very important slide, and that is that wills, when somebody prepares a will, last will and testament, wills control probate assets. Trusts control trust assets. IRAs are controlled by the beneficiary form. A common mistake that people make is the following. They will have an IRA beneficiary form that may say $100,000 goes to Billy. But then they do an estate plan, they do a trust, and in the trust document, they will actually say that the IRA is going to go to Sally. And they think that because they wrote in their trust document how they wanted that particular IRA to be transferred at death, that indication or that paragraph in the trust would override the beneficiary form. It does not. I just reviewed a trust yesterday. The whole trust was drafted, and the whole trust only discussed as to how they wanted retirement plans to be controlled upon their death. It was totally inadequate. So this is a common misunderstanding. This is a very important point. IRAs, their distribution is controlled by a beneficiary form. Some of the information that I'm going to talk about right now, I am 100% sure that you all know this, but I'm going to repeat it, and then I'm going to add some other, I'll call it specific information. But what I want to cover is that regular IRAs, not Roth contributions, regular IRA contributions, you do it with pre-tax money. That means that you never pay tax on this money that goes into an IRA. The common, I'll call it tag or nomenclature that we use with IRA type contributions is we call them the money that is contained or held by the IRA is called qualified money. Qualified money, if you hear that term, that means that the money is money that has never been taxed, pre-tax money. Non-qualified money is money that has been taxed and therefore is after-tax money. Roth contributions are after-tax money. In other words, if you want to open a Roth, you're going to pay the tax first on the money that goes into the Roth. That is why the Roth, when you die, the distributions have no tax consequences because you already paid the tax on it. And the other point is the contributions to Roths, they are not deductible. Contributions to regular IRAs, yes, they are deductible. Now, I want to go over a couple of additional, there is another slide that I want to cover before I do this, and that is that IRA contributions depends on, obviously, the type of IRAs, that a regular IRA, is that a Roth IRA, gets involved with determining the taxpayer's age, income levels, and whether the participant or the spouse is a participant in an employee retirement plan. All of these different, I'll call it, provisions come into play as to what you can contribute or not contribute and so forth to an IRA or a Roth. Now, talking about Roth IRA basics, you already know that 100% of the growth in the IRA is basically growing tax-free. While you are alive, let's assume you have a Roth IRA and you are now 74 years of age. Well, there are no lifetime required minimum distributions from your Roth. Now, I want to make a point here, and I will repeat it again in a couple of other slides, and that is that the Secure Act that passed, the 2019 provisions in the 20s of the Secure Act that passed in 2019, we'll call the 2019 Secure Act 1, because recently we just had a Secure Act 2. So Secure Act 1 basically updated the date upon which you had to take your RMDs. It changed the date from the old 70 and a half to 72. Secure Act 2.0 came into play just last year, and it changed again the required beginning date to age 23. So in 2023, the required minimum, the date to take out the required minimum distributions is 73. So let's assume that you are 74. If you had a regular IRA, you would have had to take out required minimum distributions based on an IRS table. But if you had a Roth, there are no RMDs, no required minimum distributions on the Roth while you are alive. Now, here is where mistakes are made. People will inherit a Roth, and they will remember or be aware that, hey, there are no lifetime RMDs if you have a Roth, but guess what? When you inherit a Roth IRA, there are required minimum distributions. So that's kind of like a trap that exists. Additionally, the Roth IRA distributions, they cannot be used to take the place of a regular RMD from a traditional IRA. I always like to tell the following story, and that is that when we were growing up, when we were working, everybody wanted to have an IRA. Everybody wanted to have an IRA because it was something that could be taken off your tax return. That was basically how it was marketed. That's what we did. But nobody ever told us that upon death, when the IRA would be transferred to beneficiaries, there would be all these rules that would be, I look at it like a big octopus hanging on to this IRA that you saved for all your life. And all of these various complicated tax rules now apply when you die and you transfer an IRA. The current maximum contribution to a traditional IRA is $6,500. That's up from last year, which was $6,000. And if you have a Roth and a traditional IRA, you can only put $6,500 in total in both accounts. For example, you can put $4,000 into your traditional IRA and $2,500 into your Roth, but not $6,500 into each account. That's what the reason the government does this is because they want to make sure that they get their money and just the rules that they have. The contributions, like I said, to your traditional IRA, they are tax deductible in the year that you make them. You pay tax, obviously you know that when you withdraw the money in retirement. Sometimes people tell you also that, hey, your tax bracket is going to be less when you're retired. I don't think that's 100% true. I think when you're retired, your tax brackets pretty much remain about the same. Now, I'm not going to go in all the details of what is the eligibility cutoffs if you're single or married. That gets too complicated and convoluted and changes all the time. But I am going to make another comment in reference to traditional IRA withdrawals. There might be some of you that have children that have IRAs, and one of the other pitfalls that occurs is that people who have IRAs sometimes want to take the money out. Now, if you own a traditional IRA, you can start taking out the money penalty-free, but that's after age 59 and a half. You don't have to start at that age, but if you take out money before then, there is going to be a penalty, and that penalty is going to be 10%. So we have to be aware that if you take money from a regular IRA prior to age 59 and a half, you may be subject to the early withdrawal penalty of 10%. There are exceptions to that penalty, and I will just tell you what they are. You can take money out early for qualified higher education expenses, buying your first home upon death. That's important to know. If you become totally disabled, you can withdraw money from your IRA without penalty. Similarly, if you die, your beneficiary or estate will be able to withdraw the money from your traditional IRA without any penalty. This is important for you to know. And also, the other exception would be medical expenses and health insurance premiums. And if you take payments over another method, which is called substantially equal payments, then you can avoid the 10% penalty. So the point of these slides is the following, is that we do not want to incur penalties. And I need you to be aware that penalties exist, and they will be levied against our IRAs. For example, if you remember we talked about the $6,500 contribution. That's the maximum for 2023. So you put $10,000 in your IRA and you're only allowed $6,500, get what? The IRS is going to apply a 6% penalty on the excess contribution. If you take out, like I just said, early distributions from your IRA, early distributions meaning under 59 and a half, you're going to get hit with a 10% penalty. If you allow the IRA to accumulate, there's a 50% excess accumulation. And under the new Secure Act 2.0, which I will talk about in a minute, remember that now inherited IRAs, but the majority of individuals have to be taken out. The required minimum distributions have to be taken out within the first 9 years, that everything has to come out by the 10th year. If you fail to take out the money within the 10th year, it will be a 25% penalty. Secure Act 2.0 reduces from 50%. That's a bonus. That's great. Now, Let's talk about distributions on inherited IRAs. This is really important. Secure Act 1, that's the one that was passed in 2019, that really changed the landscape with how IRA distributions now are controlled if an IRA is inherited. I'm talking about inherited IRAs. Secure Act mandates that the money that is in that IRA that you inherited, let's assume it's $100,000, you have to take it out within 10 years. And then Secure Act 2.0 added another requirement, which is now you have to take out RMDs, required minimum distributions, through years 1 through 9. So if you inherit an IRA and you don't qualify under the 5 exceptions, which I will tell you what they are, you have to take out RMDs during years 1 through 9, and by the 10th year, you have to have taken all the money out. If you fail to take the money out by the 10th year, it will be a 25% penalty. So, simple math. You have a $100,000 IRA, you forget to take the money out by the 10th year. What is 1/4 of 100,000? All you mathematicians, tell me what that is. That would be what? Tell me. Half would be 50,000. 1/4 would be 25,000. Think about it. Gee, I didn't understand what the rule was. I've had the IRA, I don't need the money, I leave it in. 10th year comes around, you didn't take any money out, 25% penalty. There's another rule that is hardly ever discussed that you have to know. This is another one of those tax traps that I want you to be aware of. It is not a common tax trap. Why? Because generally you work with a law firm that understands how these things work. But here is the deal. If you have an IRA, for example, and you do not have a beneficiary, generally the accounts by default will go to your estate. If your IRA goes to your estate as the beneficiary, the money has to be taken out within 5 years. That is horrible in a sense that all that money added to the bottom line of the person's income tax return. Can you imagine having to withdraw, let's say, a $200,000 IRA that the estate or the person inherited incorrectly, and they have to take everything out within 5 years? That's worse than the 10-year payout. Now, the 10-year payout does not apply to a spouse, to a minor child prior to their age of majority, 18 in California, disabled or chronically ill, and or an individual who is no more than 10 years younger than the IRA owner. So if you are a spouse and you are inheriting your, let's say, husband's IRA, you can continue to defer the payout over your lifespan based on an IRS table, single life IRS table, and that would dictate what your required minimum distributions are, but you will not be required to take it out within 10 years. That's critical for you to understand that. So don't panic if you inherit the IRA and you're a spouse or you qualify under some of the other 4 exceptions. What's the impact of the 10-year rule? Well, prior to the Secure Act passing, if you inherited an IRA, let's say at $100,000, and let's say you're only 50 years old, and the required beginning date for taking out the RMDs was 73, you had a heck of a lot of time there to allow that tax deferred account to grow. So it could grow for another, let's say another 30 years or so, tax deferred, compounding, and no taxes forced to be taken out until you reach the required beginning date, which would be 73, and the account obviously would grow. So what happens now? You have to take everything out in 10 years. Well, look at the chart. It's a heck of a lot less money because the account does not have the ability to grow. And the taxes are going to be accelerated because they have to be paid over the 10 years. One more item. This is important. It's not necessarily a tax trap. I want to call this a tax bonus that perhaps some of you who are working maybe are not doing it. I am working, my spouse is not working, so I try my darndest to create an IRA for my spouse. Here are the basic requirements. Who is eligible for a spousal IRA? If you're earning, or if your spouse, in this example, I'll just say wife is earning low or no annual wages, she may be able to open a spousal IRA to save tax efficiently for retirement. It's not a joint account, but rather it's a separate IRA set up for your spouse in her name. The requirement is you must be married and filing a joint tax return in order to be able to open a spousal IRA. So, what are the benefits of the spousal IRA? Well, spousal IRAs are going to offer the same tax benefits as an account in your name, the working spouse, and these tax advantages, they do come with limits that depend on the age and income, as well as the type of IRA. Like we talked earlier, whether it's a spousal IRA, opens to Roth or not, or a regular IRA. But the main benefit is that they will have a traditional IRA that they can deduct now the contribution from the taxable income. So just like your IRA benefits you, you can create a $6,500 IRA for your spouse. Worth doing it. One other point, this is a very important tax strap point, and I mean it. This is critical because I run into this all the time, and that is that I'm going to use an extreme example. Easy to follow. And generally this applies to second marriages or maybe third or fourth marriages, maybe seventh marriages. So here we go. You, wife, marry a new husband. You, wife, the original wife, you have an IRA worth $1 million. So you're the wife, you have an IRA worth $1 million, and you have 4 children from your previous marriage. Your spouse had died, your first spouse died. So you're the surviving wife with $1 million IRA, and you have 4 loving children. You fall in love, you marry a second time, and generally what spouses do is they will name their spouse as the primary beneficiary of their IRA. In this example, let's say Helen has a $1 million IRA. She has 4 loving children. She remarries Jack, so she puts Jack on her IRA as the primary beneficiary, with her 4 loving children as the backup beneficiary. She dies, the $1 million IRA goes to Jack, the surviving husband. I see this all the time, and when I make the following point, I see the eyes get large, like deers in a spotlight, you know, that saying, because the surviving spouse is now the owner of that inherited IRA. They have full control on the inherited IRA. They can leave the IRA to whomever they want. They do not have to leave it to your 4 loving children. They can leave it to whomever they want. If they get married again, your 4 loving children may never see the benefits of your hard work from your IRA. I've seen this often. It's a second marriage issue. Things can be done to help you in this circumstance. There's another family of trust called IRA trusts that are set up just for this type of scenario. Or you could, for example, bifurcate, divide your current IRA and leave a percentage of your IRA now to your 4 loving children and a percentage of the IRA to your surviving spouse. This is an important point. It is a tax trap. Now, another tax trap. You are moving, you're transferring an IRA from, let's say, company A to company B. You had an IRA maybe with, I'll just say financial institution A, and then you decided to move the IRA now to financial institution 2. Maybe you're getting better service, better rates, and so forth. So what is the best way to transfer? What is the best way to move the IRA over to the new account? Well, a rollover is when the distribution from your IRA is actually transferred to the individual's name, and they in turn redeposit the money into another IRA. One more time. A rollover is when the IRA money is given to the individual and they transfer or redeposit that money in another IRA. That is a rollover. It is not what is called trustee to trustee transfer. A trustee, I need to take a little bit of water here. A trustee to trustee transfer is when the IRA is transferred from the company's account, manager trustee, to the manager's account of the new company, their trustee. The participant never touches the money. So why is this important? Because there is a 60-day rule. What is the 60-day rule? The taxpayer must complete the rollover no later than the 60th day after they receive the money. If they do not complete the rollover by the 60th day, then the IRA total amount is considered a distribution of the full amount value of the IRA, and therefore it will be taxable. So what is the takeaway from this slide? don't do a rollover. Do a trustee-to-trustee transfer. This is another tax trap that occurs. Transfers of IRAs, trustee-to-trustee, is the better way to go. Now, this is I hope it doesn't apply to any of you. Maybe you have children, adult children that might be contemplating divorce and so forth. So I just want to alert you to something that is not, I don't think is common knowledge, quite frankly. And that is what happens to retirement accounts and what happens to IRAs during divorce? Well, retirement accounts, non-IRA, I'll call it divisions of these accounts in a divorce situation. Retirement accounts are controlled by another federal law called ERISA, E-R-I-S-A, ERISA. ERISA controls retirement accounts. ERISA does not control IRAs. IRAs transfer different in divorce scenarios. So let me tell you how they transfer. Let's assume that Jack and Jill are going through a divorce and they want to divide their IRAs. They've accumulated a large IRA, $1 million IRA, and they're going to get divorced. And so how do you split the IRA? Even if you and your spouse, or in this example, Jack and Jill, divide the assets in your IRAs and qualified plans in exactly the same way, by that I mean 50-50% to each of you, a separate legal term applies to each type of division. IRAs are divided using a process known as transfer incident to divorce. While 403Bs, 401Ks, qualified plans are split under a qualified domestic relations order called quadros. You do not want to use a quadro to divide an IRA in divorce. You and the spouse, or Jack and Jill, need to clearly identify the category into each of the retirement assets. What are they? Because if you fail to submit the information correctly to the judge or the mediator, so they are listed incorrectly in the divorce or separation agreement, it can produce unnecessary complications. One more time. IRAs are transfers under a term known transfer incident to divorce. 403Bs, qualified plans like 401Ks, they are transferred under a qualified domestic relations order. That's a court order. You must specify that your IRA is treated as the transfer incident to divorce in your agreement. If you do that, there's no tax will be assessed on the separation transaction, and the movement of the funds may be classified as either a rollover, which I told you is not the best way to go, or a IRA custodian can do the transfers. But the point here is IRAs are transferred different than 401Ks and retirement plans in a divorce scenario. It's important. I am going to now tell you about a true story. Again, I'll just use the name Jack and Jill. Jack and Jill got divorced. There was I'm going to use a large number now. There's a $2 million IRA. Jack and Jill got divorced. In this example, Jill, during the divorce proceedings, she gives up all the rights to any retirement plan all the rights to the 401k, all the rights of any type of retirement plan that existed during the marriage. So Jack and Jill got divorced, and during the divorce proceedings again, Jill gave up all her right on any retirement plan that Jack had. Guess what happens? Jack dies. Jack forgot to remove Jill, the ex-wife, as the beneficiary of his plan. The trustee of this account under ERISA paid all the benefits to the decedent's ex-wife. What's the lesson? I want all of you to review your beneficiaries on your life insurance, IRAs, 401ks, pension plans. This happens often, by the way. A lot of times on life insurance policies that maybe you had a long, long time ago, you got divorced and you never updated the beneficiary forms. So this is another major tax trap that I want you to avoid. Now, what in the heck is a qualified longevity annuity contract? What am I talking about? Have you ever heard of such a thing? What are they? Well, again, Secure Act 2.0. We have to thank that for this. A qualified longevity annuity contract, also known as a QLAC or QUAC. I'll use QUAC. A QUAC is an annuity purchased from an insurance company using assets that were part of your IRA. Prior to Secure Act 2.0, there was a premium cap on these type of annuities, and it was relatively low. The maximum that you could put in would be $125,000 as a premium. But thank you to the law in Secure Act 2.0, now there is no cap, and now you can put in a maximum premium of this annuity of $200,000. Okay, so you buy an annuity with IRA assets. You can put in a premium up to $200,000. So what is the advantage? When you have one of these type of annuities, you can elect to defer the premium, the payments, the RMDs, any payments, until the month after you turn 85. Remember, if you buy accounts that are IRA type accounts, you have to start taking RMDs by your required beginning date that is now 73. And now you can delay that beginning date up to age 85. And they can also help lower your RMDs because the money from these qualified annuities are not included in a calculation that determines how much you need to withdraw from other qualified accounts. And these type of annuities could be viewed as Medi-Cal compliant annuities, which can be used for long-term care coverage when you need it. I want you to learn about these type of annuities because it's not a common investment vehicle. And it's important that you understand some of these new tools that exist, particularly this particular one that has been enhanced by the Secure Act 2.0. All right. When you choose a custodian of your IRA, you need to ask a lot of questions because not all custodians are equal. For example, does the custodian permit per striptease? What does that mean? Well, allowing you, for example, to leave an IRA, you leave it to a child, if that child dies, it goes to the grandchild and so forth. And will the custodian recognize that you want to create what we call a customized IRA beneficiary form? In other words, do you want to customize your distribution, maybe 50% to child A, 25% to child B, 25% to child C, and if one dies, et cetera, what happens? And a lot of custodians, they will not want you to give them a customized beneficiary form. They will want you to use their form. And the other one is, can the beneficiary of the account name their beneficiary? Can the client name a trust as a beneficiary? What are the default provisions in the plan that your IRA has? There's a lot of questions that you have to ask the custodian, because once you open an IRA account, that IRA account is controlled by that custodian plan. So this is another, I'll call it tax trap, in the sense that people open IRAs, they don't discuss what the options are going to be for them. This is very important. And I know a lot of you already have good custodians. Maybe you should have a conversation with them about this. All right, we're at the end. A lot of you are our clients. Some of you are not our clients. So I'm just going to give you a 30-second as to who we are. We're Copeland Barger Law Firm. We've been around since 1979. 8 full-time attorneys, 2 lawyers of counsel. There's the CPA, combined experience over 350 years. Half of us are certified specialists in probate, estate planning, and trust law. That's a very, very prestigious designation that's issued by the State Bar of California. We have to take another bar exam in order to get this designation. Half of us have advanced tax degrees, and there's over 43 highly qualified support staff. So we're all here to help you. Our job is to really help you, and whether it be creating a trust, creating a will, updating your estate plan, and so forth, that our job is really to be here to help you. We are here to help you. We would love to hear from you. We have a team standing by, ready to assist you with any questions or comments that you may have. I did not get to any of your specific questions. Write me an email and I will call you back and I will discuss the questions with you. And at this juncture, I want to remind you that you will be getting a phone call from our company asking you if you want to schedule an appointment. And again, I want to thank everybody. I want to really, really, really thank you for joining me. And I hope that you have a wonderful, I guess it's Easter. Today is Ash Wednesday. And also, I think we're going to have St. Michael or St. Patrick's Day. Thank you very much for attending. And when you come to the consultation, bring with you any estate planning documents that you may have. If you're going to make an appointment, we will send you a confidential data questionnaire and update it, and then again, provide the questions that you may want to ask. So thank you so much, and I will bid you goodbye